Mendel. Thank you all for coming. My name is John Goldberg. I'm a faculty member here at the law school, as is my colleague Henry Smith. We are the co-organizers or hosts of this event. I'm going to briefly introduce our panelists and then give you a few basic facts about Langdell, and then turn it over for our panelists to make some remarks, and then we'll open it up for questions. So, in order of presentation but not seating, our first speaker after myself will be Professor Catharine Wells, who is Professor of Law and Law School Fund Research Scholar at Boston College Law School, where she writes in pragmatic legal theory, feminist jurisprudence, and civil rights theory. She has previously served as Associate Dean for Academic Affairs, condolences, has also been the chair of the Association of American Law Schools section on torts and compensation system and the section on teaching method, and she is in the process of publishing a book about Oliver Wendell Holmes Jr. and the pragmatic tradition in American law. Our next presenter will be Brian Leiter. Brian Leiter is the Carl N. Llewellyn Professor of Jurisprudence and Director of the Center for Law, Philosophy, and Human Values at the University of Chicago Law School. He joined the Chicago faculty in 2008 and 2009, at which time he founded the center. Previously, he taught for 13 years at the University of Texas at Austin. His teaching and research interests are in moral, political, and legal philosophy and the law of evidence. He's the author of numerous books on jurisprudence and moral philosophy, and is the editor, or was an editor of the journal Legal Theory, and a founding editor of the Routledge Philosophers book series and of Oxford Studies in Philosophy of Law. Last but not least, at the far end is Professor Anthony Sebok. He is Professor of Law at Benjamin Cardozo Law School. Professor Sebok is an expert on mass torts, litigation finance, comparative tort law, and legal philosophy. Before joining the Cardozo faculty in 2007, he was the Centennial Professor of Law and Associate Dean for Research, condolences, at Brooklyn Law School, where he taught for 15 years. He was also a fellow in a program in Law and Public Affairs at Princeton University from 2005 to 2006. And in 1999, he was a fellow at the American Academy in Berlin. He has authored numerous articles on litigation finance, mass restitution litigation, slavery reparations, and is the author of Legal Positivism in American Jurisprudence. So, as you can see, we have a very distinguished panel here to discuss Langdell. I'm here just to introduce the man and, if you will, set in a very minimal way the historical context. So here is the man. Langdell, one of his famous portraits from 1870 or so. You can see he lived for the better part of the 19th century. He came from very mixed backgrounds. He was the son of a farmer who struggled economically and managed through the generosity of others to basically get a scholarship, if you will, to Harvard and Harvard Law School, where he was a quote-unquote pauper scholar, and thus didn't fit in with a lot of the more well-to-do students he was hanging around with. After law school, he practiced in New York for a full 15 years and had quite a successful commercial practice, as it would have been back then. He was then hired by the famous university president Charles Eliot to be a faculty member of the Harvard Law School, and Eliot, who had met Langdell years earlier at Harvard, brought him in specifically to be a change agent at Harvard. And as soon as he got to Harvard, Langdell was appointed dean. Now that sounds pretty remarkable, but you have to remember that in 1870, what it meant to be dean was to basically be the secretary, to take minutes at faculty meetings and not do much else. But Langdell had a grander vision, and he actually turned the deanship into a seat of reform and renovation. So, and was quite controversial among his colleagues for this. He was determined to hire scholars as opposed to the tradition of hiring practitioners to teach. He wanted to hire researchers and writers, so people like me owe him our jobs, the people who spend their time reading and writing and not practicing. That whole idea of a law professor was very much Langdell's. He realized that if you were going to be a great law school that was going to last for 200 years or more, you had to have a fantastic library, and he devoted resources to creating what is now formerly the Langdell Library. He raised admission standards and academic standards. When you started at Harvard Law School, the way you made it through law school is you took classes and then your professors blessed you or didn't. There were no exams. It was just, did they think you were smart or not? Langdell said, maybe we should have some exams to see if anyone actually knows anything. So, in fact, quite an innovator, and of course he was most famously associated with pedagogic innovation known as the case method, which we'll talk about, I imagine, some today. I won't belabor it except to say that, of course, the case method, which he started at Harvard, teaching law students through the presentation of a sequence of cases, has sort of dominated legal education in the United States since he introduced it. And he really was the first person to produce a case book, a modern-style case book, the law of contracts. By the way, for you students, no notes, just cases. No expository text, no guidance, just cases. Okay, so to give you a sense of what Harvard Law School was like in the Langdell era, well, this, I don't know if you can read it very well up there on the screen, but this was the sort of annual publication of the Harvard University Law School, first page, 1870-71. You see there's, 6 faculty members, and then you'll see the required studies. Personal property, real property, contracts, torts, criminal law and procedure, civil procedure, evidence. Not shockingly different, right? And a source of criticism of law schools today that the first-year curriculum and the required curriculum don't look shockingly different today in 2017 than they did. Well, we can talk about that too. This is what a classroom looked like in about 1870. Nothing very fancy. You're all doing better today than they were in 1870. Of course, the reason we're here, one of the reasons we're here, is because Langdell is famously associated with something called legal formalism. A lot of what we're going to talk about today is what does this mean, and what does it mean to be a formalist, to be against formalism, etc. But the great antagonist here, of course, is another even more prominent Harvard Law graduate, Oliver Wendell Holmes Jr., who in a book review, reviewing the second edition of Langdell's casebook on contracts, offered the following assessment of the book and the sort of philosophy behind the book, if you will, and I'll quote, "Mr. Langdell's ideal in the law, the end of all his striving is the elegantia juris, or logical integrity of the system as a system. He is perhaps the greatest living legal theologian." Now, coming from Holmes, those fighting words. He rendered this criticism, and ever since, basically, people have used Langdell, or some people have used Langdell as a kind of punching bag, intellectually speaking, and so we're going to talk about why they do that, whether it makes sense, and so forth. So that's just setting the stage. I'm now going to hand things over to Professor Well.
Hi. My thanks to John and Henry for organizing this. It's really a pleasure to be part of Harvard's 200th anniversary, or the law school's 200th anniversary. And I'm especially pleased to be talking about Langdell, who, by his teaching and by his leadership as a dean, not only influenced Harvard, but all of legal education, actually for a century to come. So that's a very big legacy. But I'm not going to talk about the big legacy today. I'm going to talk about his career as a jurisprudent, as somebody tells us about how law ought to be formed and decided. And in that connection, he has become a straw man. Probably the biggest straw man in American law, because he does, as John said, stand for formalism. And for a particular kind of formalism, this is sort of the essence of what people attribute to Langdell, the notion that law is disconnected from the real world. Unlike the realist, he doesn't think that we need to take it into account, that employs a deductive method, and he means in particular a syllogism, or what the logicians call modus ponens, and then, of course, there is the assertion that every legal case has one, only one, right answer. So that's what Langdell's formalism is supposed to look like. I want to say a little word here about modus ponens, which is if you go to a modern logician, they won't talk about syllogism. They'll talk about the rule of modus ponens, which is the familiar one. And you can see chocolate is a dessert. I love dessert, therefore I love chocolate. What gets us from 1 and 2 to 3 is the rule modus ponens. Okay. Well, so oops. Okay. So anybody who's read a lot of legal cases, and I'm betting that most of you have, will find the idea that law's deductive logic somewhat implausible, I suspect. But what's interesting, of course, is that logicians find that implausible as well. And so I thought I'd talk about that today, because we have, I think, beaten Langdell as the formalist to a pulp, and it's time to look at it from a different point of view. So I have a particular logician in mind, and his name is Lewis Carroll. I suspect you've all heard of him. He saw in logical reasoning and in modus ponens a difficulty that no one had ever seen before. And so what I want to do is explain to you Carroll's paradox and why it's relevant to putting a nail in Langdell's coffin as a jurisprudence. So it begins with a story, and the story is this. The tortoise walks up to Achilles, and he takes 3 propositions from Euclid. 2 are premises, and the 3rd is the conclusion. And they are, in fact, related by modus ponens. So he says, well, I believe 1 and 2, but I'm not sure about this conclusion. I'm really going to need some persuading to get to the conclusion. So Achilles is happy to help. Sorry, I'm technologically challenged. Oh, I see. Yeah, that's right. Okay. So he's happy to help, and so he begins with the 2 propositions from Euclid, 1 and 2, and the basic premises of modus ponens. And then he says, well, if 1 and 2 are true, then the conclusion must be true. So he asserts modus ponens. And then he turns to the turtle and says, now you see, if you believe these 3 things, then you have to believe the 3rd. But the tortoise isn't satisfied. Not enough. I'm afraid I'm going to need 1 more premise. There we are. Sorry, I have never used one. Okay. I'm afraid I'm going to need 1 more premise. This is cheating. This is cheating. No, it was the keyboard that was right underneath it. Did it? All right. Yeah. So the tortoise is still not satisfied. He says, you know, I get 1 and 2, and I get 3, which is if 1 and 2 are true, then the conclusion must be true. And I get 4. 1, 2, and 3 are true, then the conclusion must be true. But I still need something that tells me that if these 4 things are true, there is a conclusion. So Achilles says, okay, at last we've got to the end. I'm going to add this 5th one, and we'll put it on the list, and then you can accept the conclusion. Do I, said the tortoise innocently? Let's make that quite clear. I accept A, B, C, and D, but suppose I still refuse to accept Z, which is the conclusion. Now that you've accepted 1, 2, 3, and 4, Achilles replies, you must accept the conclusion. You have no choice, you see. Then logic would take you by the throat and force you to do it. Achilles triumphantly replied, whatever logic is good enough to tell me, the tortoise said, is worth writing down. So enter your book, please. We will call it 5. If 1, 2, 3, and 4 are true, then the conclusion must be true. Until I grant that, of course, I needn't grant the conclusion. So it's quite a necessary step, you see. I see, said Achilles, and there was a touch of sadness in his tone. Well, the problem here, of course, is that there's an infinite regress. It should remind you a little bit of Zeno's paradox, where you keep getting halfway there, but not all the way there. you have to keep adding a premise. And you never get to the conclusion. And why is that? So, what it does not teach us about legal reasoning is that the tortoise is simply refusing to be logical, right? I mean, we're not just dealing with somebody to whom you say, well, this is true, so therefore, I'm still not going to believe this in some kind of rule-breaking way. Instead, the tortoise is making a deeper point about what it means to be logical. To make a logical argument, and this is very relevant to Langdell, if you're going to make a logical argument, you can't just have propositions and premises. You have to have something called a rule, because it's the rule that licenses the inference. The propositions and the rule are not the same thing. Once we write down the rule, once we treat them as a declarative sentence, they lose their compulsory character. They become simple propositions that describe something rather than the performative words that the rule is that regulate conduct. So that's the problem. We have this fundamental difference between rules and propositions. So what does this tell us about Langdell? To say that somebody must do something is to say that there's a rule that requires it. Understanding a rule is to know what it requires in a diverse range of situations. But no rule can be fully stated. Every rule has exceptions. For example, coffee at 7 may mean different things during daylight savings, or on holidays, or when the servants get a day off, or when the coffee machine is broken. Rules are not declarative sentences. If they were declarative sentences, we'd never be able to draw any conclusions. So, I know how to fix this. That's Langdell. So Langdell invented contract doctrine. That was a sizable achievement. He developed an analysis of contract formation that was far more complicated than anything that had gone before. And from this analysis of contract formation, he was able to see a lot of logical relationships between the requirements of formation and what you would do under certain circumstances. He invented a rich theory of contract, which provided for a sort of uniform theory of the cases, how you would look at the cases. At least that's what he thought he did. So he did part of that. He enriched the way we talked about contract law by creating an analytical construct that we now call contract doctrine. He was so good at it that 100 years later it's still being taught in contracts cases. He noted the logical relationships between the doctrine and the cases. That helps students learn. His framework was in fact very useful for a lot of things. Organizing treatises so that lawyers could find relevant cases, organizing briefs, teaching contracts without requiring students to memorize large numbers of cases. Students have benefited from that for 100 years. These are useful things, but what he did not do, what he could not do, is the thing everybody attributes to him, which is to demonstrate that law is simply logic, that judges must decide cases based on syllogism. As the tortoise showed us, no amount of contract doctrine can force a judge to make a certain decision. It cannot even prove what decision would be logical.
Thank you very much. We're next going to hear from Brian Leiter.
Thanks, John. Why did Langdell develop the case method of legal instruction? And I want to say a little more about the case method, though some of this was already suggested by Professor Wells' remarks. The idea of the case method for Langdell was that by studying the cases, the decisions of the courts, you could engage in a kind of inference to the best explanation about the general legal rule or principle that explained the particular decision. And you do that enough, you could eventually put the whole area of law together in terms of the basic doctrines and then the points that are derivable from the basic doctrines. Now, and this was a complete change from the way law was taught at Harvard before Langdell. Before Langdell, it was largely a matter of recitation and repetition of things in old books. So this was a very dramatic break. Now, why did Langdell introduce this method? In the 19th century saw the birth of what we know as the modern research university, of which Harvard is, of course, an important American paradigm. But the research university in America was formed on the basis of the German model. And here we owe the conception of the research university to Wilhelm von Humboldt, who was very influential in establishing the modern German university system. And Humboldt's idea was that what distinguishes a university from a trade school or some other institution that teaches skills is that universities are homes to disciplines that are Wissenschaften. Wissenschaft is the German word for science. Now, unfortunately, science in English has the connotation of natural science, and that's completely wrong in this context. A Wissenschaft, right, refers to any discipline where there are teachable methods for investigating and discovering the truth about some aspect of the world. So classics was a Wissenschaft, history was a Wissenschaft, anything that belonged in the university had to be a Wissenschaft. That is, it had to involve clear methods for discovering the truth about its subject matter. And this vision of what a university is in the background of what Langdell was trying to do. Langdell was trying to show that the study of law was indeed a science, right? And it was a science that involved a method. As he famously said, the case book is the laboratory, right, of the lawyer and the legal scholar. We study the cases, right? We draw inferences about what general doctrines seem to explain them. We try to reconcile apparently different decisions to finally elucidate the general structure of the legal doctrine in some area. Right? And so Langdell's great contribution was to show that the study of law belonged in a university because it was actually a Wissenschaft. Now, what about the famous legal realist reaction to Langdell? John Goldberg gave us one of Holmes's choice remarks about Langdell. Starting in the 1920s and 30s, many other of the American legal realists, Carl Llewellyn, Jerome Frank, Herman Oliphant, and many others, began launching an attack on Langdell's formalism, often in conjunction with an attack on Joseph Beal, another Harvard law professor, his formalism as applied in the conflict of laws. Now, the important thing to understand about legal realism, and I think legal realism has suffered from a great deal of caricature over the years, partly at the hands of the critical legal studies professors at this law school. An important thing to understand about legal realism was they shared Langdell's ambition that the study of law be scientific. They didn't have any disagreement with Langdell about that. What they disagreed with was the quality of the science that Langdell was doing. Right? And their objection, in essence, boiled down to this. They said Langdell's mistake was to read the cases of the courts and take far too seriously the very general statements of legal doctrine that the courts invoked as an explanation of their decisions. And the realists said, actually, the very general statements of doctrine tend to be misleading about the actual basis for the decision. And let me give you a very simple but famous example from the realist canon due to Herman Oliphant, who was a law professor at Columbia for many years. Oliphant said in a famous lecture in the 1920s, he said, look, there are two lines of cases about promises not to compete. And in some cases, the courts uphold the promises, and in other cases, the courts do not enforce the promises. They find them to be invalid. And Oliphant says, if you try to reconstruct the divergent lines of decision in terms of general doctrines of contract law, right? Was there a failure of the meeting of the minds? Was there some other kind of mistake that vitiated the contract, and so on? He says you can't make sense of what's going on in the cases. To understand the cases, and now this was the realist innovation in legal science, said you have to look very carefully at the underlying facts of the case. And in particular, you have to see that cases fall into patterns of decision that are organized around what realists typically call situation types. Types of factual situations that recur and to which the courts have similar responses. Okay? So in the case of the promise not to compete cases, Oliphant says, in order to understand what was really going on, you need to notice that in all the cases where the court enforced the promise not to compete, it was a promise by a seller of a business to the buyer not to simply set up shop next door and compete with him. And Oliphant says, of course the courts enforce those promises because otherwise the transaction would have been economically pointless. Right? What's the point of buying the restaurant if the former proprietor just opens up across the street? Right? So any other decision wouldn't have made any good economic sense. By contrast, says Oliphant, all the cases where the courts, right, do not enforce the promise involve promises by employees not to compete with their employers after leaving the employment. So we have, in this case, Oliphant says what's really going on is that such promises were disfavored by, as he puts it in the language of the guild regulations. Trade guilds strongly disfavored binding employees this way. This wasn't a legally codified norm, but it was one to which the courts were sensitive and thought was basically fair. Right? That is, it was unfair to bind the apprentice baker to the baker for the rest of his life, even if he stopped working for that particular bakery. Okay? So, to understand the cases, to read them really carefully, you have to identify situation types and then see what kind of normative considerations are leading the courts to treat these situation types one way rather than another. Now notice that this way of looking at cases isn't really inconsistent with Langdell's ambition. And indeed, the second restatement of contract actually incorporates something like, not exactly, Oliphant's distinction between different kinds of promises to compete. And in that sense, the realist ambition was really a fulfillment of what Langdell was trying to do. They just thought they were doing it better. They were being better scientists of the law. And in a nutshell, we can say the goal was to state the rules governing the decision of the cases at a greater level of factual specificity, such that we identify a type of factual situation that courts think has a normatively significant feature. And once you codify that to the extent you can, you have something that looks very much like the original ambition of what Langdell was trying to do. So I think there's actually a deeper continuity between Langdell's ambition and the realist revolution. Though one thing we do owe the realists is the fact, as John mentioned, right, Langdell was just cases. And the realists gave us cases and materials on the law of X, because part of their hypothesis, right, and now this is related to what Professor Wells said, part of their hypothesis was to understand what types of situations the courts took to be normatively significant. You had to understand things about the social, historical, economic, and political context. And that was the point of the materials, right? You had to know, for example, that there were trade guild regulations, right, that strongly disfavored binding employees to employers in perpetuity. And I think that's a good place to stop. Thank you.
Thanks very much, Brian. And now we'll hear from Professor Sebok.
Okay, well, thank you very much. I want to thank John and Henry for inviting me, and I'm very pleased to be on a panel with Catharine and Brian, who are wonderful old friends and colleagues. I'm going to talk a little bit about why Langdell isn't scary like others here, and then I'm going to say something about Langdell which will make him sound really scary and make you dislike the Langdell I present and perhaps dislike me. There are a number of myths about Langdell that have been already mentioned. I'll mention them again. The chief ones in my mind are that he thought that law was like geometry. You can blame that on some of the realists, especially Grant Gilmore. Gilmore mocked Langdell for imagining that you could reduce legal principles to a very small number, and that you could represent these legal principles in a very small number of cases. There's another myth that Langdell thought that the common law was ahistorical and was actually a set of ideals that were not rooted in any historical experience. You could blame this on Felix Cohen, who used the expression transcendental nonsense to describe Langdell's work. You can also blame it on Holmes, who talked about him as a legal theologian. Oh, by the way, the other great quote is from Holmes is that he was a representative of the powers of darkness. And then the other myth is that Langdell thought that legal art was logical only and deductive. Now, the reality is that to the extent that Langdell was interested in science, whether in the expanded expression that Brian uses or the more narrow sense that we use in the Anglo-Saxon vocabulary, he certainly was much more of a mind that it was like biology or geology, which actually in the 19th century were the sort of state-of-the-art, sort of high-tech, computer-like new technologies of the moment, Darwin, etc. Also, he never expressed an opinion about the metaphysical status of law. He was, in fact, a little bit allergic to philosophy. He never suggested that he thought law was not historically contingent, and that it would not vary, in fact, by culture and nation. In fact, he observed that a system of contract, like the one in civilian systems that did not use consideration, could be perfectly operable. It just wasn't the common law system. So you can imagine other nations having different premises than the premises that were in the common law that he was analyzing. So there's absolutely nothing to suggest that he was a transcendentalist. And finally, and most importantly, famously, both in his academic writing and also in his pedagogical method, he was not motivated primarily by deduction. He was motivated by induction. I mean, he started off with 2,000 contracts cases. He sifted through them. He drew them, the ones out that he thought were representative of the deeper principles that were contained in the many. This is why he compared his method to a laboratory of samples in botany, not to the cloistered office of the logician who was working with paper and pen working on angles. I mean, he really thought that the knowledge that can be gained from law had to be done inductively. Now, that's the sort of sense of reality I want to emphasize about Langdell, but I also don't want to ignore that there was something about Langdell which really justifiably annoyed people for the last 100 years, and that is he did sound like a little bit of an idiot when he said, for example, of the mailbox rule, the famous rule that said that a contract was only complete when the acceptance was received, not when the acceptance was mailed. And he said, this is a quote, he said, although the new rule that people are pushing, this radical new rule that that the will theory would suggest that you have contracts completed when the acceptance is submitted and in the mailbox, not when it's received. He said, although he could see how that would serve substantial justice, the true answer to this argument is that it's irrelevant, he said. Substantial justice is irrelevant to the analysis of whether or not a rule of law presented to a court was correct or not. Now, for Holmes, this meant that Langdell rejected experience. I want to stress, Holmes himself was not that much interested in the force of substantial justice either. Holmes was interested in the force of experience. And for the realists, many of them, I think the rejection of substantial justice was tactically and philosophically very worrisome because they saw this as reinforcing and entrenching social interests, interests of conservative social interests that they would like to have seen subject to revision by the courts. So we have this paradox in Langdell. We have a paradox where his legal theory is understood by us today, incorrectly, to be one based on deduction and anti-empiricism. And then we have this other story, celebrated by people here, a whole building in this law school, of his pedagogical approach. His pedagogical approach is represented, everyone agrees, by an emphasis on induction, the case book, right? And empiricism. If you look at not just the case method in the classroom, but also why did he introduce the exams that he introduced? Before he introduced the exams which were problem-based, exams, if they existed at all, were based on memorization of simple rules in text. He wanted to have students prove that they could take basic facts and analyze them in much the same way we still have the exam today in the first year class of a fact pattern. And finally, he was the one who wanted interactive classrooms. He wanted to have professors talking to students, calling them, and he was the first to admit that that legal interpretation was always provisional. You know, the famous line is that someone said observed that in the classroom, he observed that over the course of 2 weeks of classes, he changed his mind 3 times about whether a case was properly decided. He saw nothing strange about this. Celebrated as the great sort of inductive reasoner. Celebrated as the great active participant in the inquiry of law as a living thing. So we see these 2 parts of Langdell. And one thing that I'm very interested in is why did he seem so committed to what I think is the truer side of himself, this inductive, empirical side? Why did he seem so committed to this in legal education? And there's a line that Professor Goldberg tipped me off to, which I think is very intriguing. It's a line from a book about the history of Harvard Law School, where the authors say that based on Langdell's 15 years of practice in New York, and this is a quote, he could not, this is the author's opinion, but I think it might be based on very good foundations, he could not teach that judges decided cases based on their own sense of fairness and policy. That, and this is the key phrase, that was the road back to Tammany Hall. Cases decided on whim. Now there's something very striking about that, because there's an equation in Langdell's mind between deciding a case on fairness and whim, right? And so Langdell felt compelled, if he was going to help improve the law, to bring lawyers and judges, those who would be deciding cases and arguing cases, away from any temptation to base law on human passion or human desire and human judgment about justice, and to base it on something objective and scientific. So he saw no conflict between this caricature we have of him as the legal scientist and this true example we have of him as a legal educator based on trying to promote a growing understanding of law as a series of propositions to be defended by argument. So that is why he desperately wanted to promote through education a certain conception of legal science. Now, the part that I want to pivot to for a moment is to sort of observe the following. That if that's all we had of Langdell, and if that's all we had of law, what we could see is growing evolution of expertise in the analysis of laws and legal science. We could have, and hopefully, a greater sort of precision in our judgments about what are the right and wrong propositions of contract law, what are the right and wrong propositions of property and tort law. But we don't really have that. What we have is we have a rich and full acceptance of the pedagogical methods of Langdell, and then we have a struggle in American law of something else. What we have in American law between 1870 and 1930 are 2 things. One is the growth of Langdellian method in the law schools, and the other is a stalled effort to professionalize the legal profession, to professionalize law. Here's some interesting statistics just to remember. In the 1870s, law was not a regulated profession. As of 1927, no state required law school education for the practice of law. And 80% of lawyers, this is 1927, had no formal education. They had apprenticed, like Lincoln. Right? Now, a lot changed then in the 1930s. And by 1941, 41 states had required graduation from an ABA accredited law school. And throughout the 1930s, there was this rapid effort by the ABA to pass legislation, to have legislation passed that would prohibit the corporate practice of law, the involvement of non-lawyers in legal practice, and to invite the courts to declare certain activities as the unauthorized practice of law. Now, what am I interested in here? I'm interested in the following, that Langdell's educational philosophy succeeded fully in the United States between, say, 1870 and 1930. What did not happen, though, was law was then broken off as a separate self-regulating profession. And I want to make the following concluding observation, and it's an invitation. I can say some more provocative things, but maybe my time is growing short.
Go ahead.
The thing I want to stress is the following. Now, I teach legal ethics. I write about the legal profession, and I fully appreciate, especially in an audience like this, all of the important values that come from having law be a profession and having it as a profession regulated by those who are able to monitor and control the quality and the integrity of lawyers. So let's begin with the premise that there is no question here that we need to have professional self-regulation. However, we should not forget that there are always costs to regulating an activity as a profession. The gains, I think I've already alluded to, right? Consumer protection and the bettering of society by having the right kind of values held by those in critical places to change the direction of social change. However, the costs are also that literally you make law less available to people. I mean, when you create a monopoly, you raise the price. And furthermore, when you create a monopoly and raise the price, you take out of the hands of some people who cannot or do not want to become part of the profession or may not be able to satisfy all those professional skills, the opportunity to provide services that they could do perfectly well. Now, what's interesting to me is that during the 1920s and 30s, when the assault on the corporate practice of law, and when the assault on unauthorized practice of law was led by lawyers, the main argument was not consumer protection. By that point, we'd had enough experience seeing people who were not licensed as lawyers providing the opportunity to write wills for people, providing the opportunity to help people write contracts. Enough experience that it could be identified by legislative committees that there was not any obvious problem with consumers being poorly served by these non-licensed actors. The argument that won the day was the argument that there's something called professional judgment, something related to the core values of the profession, which these non-lawyers did not possess. And that led, of course, to the restriction of individuals to practice law only either as individuals licensed by their bar or by the court, or to partnerships. For example, the key argument why corporations could not practice law or why a non-lawyer could not invest in a lawyer was that they would invade the core values of legal practice. They would, in fact, infect the judgment of the lawyer with their non-lawyerly commercial attitudes. And you see this throughout the 1920s and 30s. You see the argument that commercial values are different from those of lawyerly values. And that won the day. So the final point I want to make is the following observation. There's no obvious entailment between perfection in legal science and professionalization. You can actually have universities teaching legal science. You could have people who are excellent in analyzing rules, however we understand legal science to be defined, without having them then licensed as professionals. So for example, the state could say, as we often do with science today, there is a separate discipline of botany or biology, but with no need to say that if you want to talk to someone or ask someone about whether or not a claim is true in botany or biology, you can only go to someone who has been identified and regulated by a self-governing group of botanists or biologists. In that sense, Langdell's argument that we should expand and perfect legal science is completely separate from the argument that we should have a legal profession that is defined by more than technical capacity, but one that is defined also by a certain normative identity. And my conclusion will be the following. It's not hard to see why that would be appealing to the realists. Because after all, The realists were trying to argue that being a lawyer and judgment in law was more, in my opinion, than perfecting certain claims about legal science and accuracy about legal propositions. It was, in fact, being able to add a certain capacity of normative judgment necessary to good legal judgment. That was exactly what was missing from Langdell. He said it wasn't important. If you really believe, that lawyers in their finest and most excellent form are not just scientifically competent, but also possess a certain kind of normative capacity, then you are challenged with the process of identifying those normative values. And this is exactly what the bar did. The bar declared for itself to be the arbiter of something called the normative structure, the core values of legal reasoning, which have many wonderful sounding platitudes attached to them, but they do serve a very specific purpose. They exclude anyone who's not been deemed to possess those qualities from the practice of law. I'm going to end there because I think I've probably said enough.
Thank you so much. So I'm sensing already some disagreements that might be lurking on this at this table, but before we get to that, I'm going to ask my colleague Henry Smith to offer a few observations and responses, and then we'll open it up for questions.
Okay, so I don't want to get in the way of a disagreement, so I'll just say a couple of things. Thanks. So I want to add to the notion of Langdell as a paradox. Many times when you identify a paradox, the way to look at it, or the potential solution, is to ask whether there's some hidden domain, some restrictive domain over which you're talking, or maybe you're talking over multiple domains at the same time. The one I'd like to add to the mix here is the old law versus equity distinction. So Langdell worked in the era when the fusion of law and equity was already underway and was proceeding in various jurisdictions. And it seems to me, and I'll give a few quotes in a minute, that some of the image of Langdell comes from looking at his statements about the law and not underplaying or leaving out his statements about equity. So there used to be separate courts of equity, and they had a different style of reasoning and so forth, and they sometimes overrode the law and so forth. Now, one very interesting thing about Langdell was that he was, if anything, equally famous for his equity course at the law school. As I recall, his equity course was more popular than his contracts course, and he also wrote extensively in equity as well. And he took a very conventional sort of Aristotelian-inspired view of equity, and like Ames, he thought that equity was an important part of the overall system, but it was a separate system. It was a subsystem of the law, but put together with the law, it furnished the entire legal system. So he says, the object of equity in assuming jurisdiction over legal rights is to promote justice by supplying defects in the remedies which the courts of law afford. The jurisdiction is co-existent, extensive with its object, that is, equity assumes jurisdiction over legal rights so far and so far only as justice can thereby be promoted. Now, some people, especially in the critical legal studies world, have said, well, that's just a matter of remedies, and remedies is a peripheral subject and one that we don't even teach really much anymore. So, first of all, I think we probably should teach it more, but when Langdell talked about remedies, he was not talking about the current remedies course or remedies defined as a field. He was talking about something much broader. So here's another quote. Of course, however, it must not be supposed that equity in modern times is simply a different system of remedies from those administered in the courts of law, for there are many extensive doctrines in equity and some whole branches of law which are unknown to the common law courts. It may be said without impropriety that equity is a great legal system which has grown up side by side with common law and which, while consistent with the latter, is in great measure independent of it. Now, when we're talking about the role of equity, I mean, he was talking about whole areas of law like trust. He was also talking about what we would call unconscionability and things like that. Now, when courts were doing that, they certainly were doing something that sounds a lot more realistic and a lot less formalist than the image of Christopher Columbus Langdell usually affords us. So, for instance, he would say things like, questions of jurisdiction do not receive the same careful and constant attention which is bestowed upon questions of substantive right. And therefore, in dealing with such questions, the elements of haste, accident, caprice, the habits of lawyers, the leanings of individual judges, and the ever-changing temper of public opinion have been factors of no inconsiderable importance. So, when you add that back into the mix, into the overall system, it doesn't seem to me that the picture of Langdell as some kind of legal idealist with deduction on the brain all the time is really entirely accurate or even close to the mark. Now, that's not to say that Langdell didn't say all the things that people say he said, but clearly there's more going on here. Now, it seems to me that basically the problem is that the legal system in his day was undergoing a big change from a hybrid system in which courts for jurisdiction within a single court specialized. One aimed at general statements and was more formalistic, and the other was much more particularized and let all sorts of context in a way that equity courts did. That kind of specialization was hard to maintain. It was not going to be reinforced by the courts anymore, and it was really a question, and it still is a question, how much those two approaches have to be fused with each other and how. And it seems to me that you have basically two or three ways to go. One is to say, well, yes, we've fused the courts, but we're still going to engage in this Amesian, Langdellian specialization, which means that we have a hybrid system where it's doing one thing at one time and another thing at another time, and that's just the way it goes. And you can argue, well, we shouldn't do that, and then the other way is to say, no, we should have a homogeneous system that pretty much tries to do the same thing all the time, and that might be more formalist, that might be more contextualist, and you have certainly people who advocate for one or the other. And from our latter-day point of view, the kinds of things that people said in the Langdellian era tend to speak to us as addressing that choice. Should we be more formalistic? Should we be more contextualist? But that's asking a different question, perhaps, than the kind of questions that people like Ames and Langdell were asking when they were trying to build up a more hybrid system of the kind that I was describing. But again, that's just by way of increasing the paradox, but not diminishing the disagreement.